Good evening. My name is Abis Pokrail with student ID KTM 2373. I'm here with my group members for the presentation of business and corporate law. We are group number M5-19. I'm going to begin with the case of SO Burgers that is related with the contract law. At the beginning, we need to know what a contract law is. A contract is a legally binding agreement. It's usually between two parties, and in a contract, a party offers something to a different party. In the case of SO Burgers, the issue was the SO Burgers made an offer where they asked their customers to collect 50 tokens, and each token had, with the collection of 50 tokens, they could get a ticket and which they can scratch and get a golden car in return. The issue here was both Mickey and Brett, they collected the tickets and successfully should have won the car, but SO Burgers, they denied them. So according to the rules, if the offer states that a reward should be given in return of a particular activity, then it should be given to the deserving winners. Contractual rights apply if the requirements of the offer have been met, and offer can only be revoked if before the winners fulfills their requirements. If you go into the analysis of the SO Burgers case, since both Brett and Mickey had already collected the tokens and received the golden ticket, they should be winning the reward because the offer was still valid when they collected the tokens. In this case, SO Burgers cannot revoke the offer since they had already collected the tokens with the intention of claiming the award. Furthermore, my group mate Wahaz will continue in this case.
Thank you, Abish. Hello, my name is Wahaz Shabir, and my student ID is VSS3904. And I would like to continue with the clerk. Are we clerk? This is a law, and it is required of a particular contract have been met. Then the other person who fulfills the requirements is entitled to receive the award that is promised. And if the offer does not provide the price and does not provide the price of the reward that provide the that was promised. I'm sorry about that. Provide the price or the reward that was promised, then he or she will be sued. And the next one is. And the conclusion for this the case, SO Burgers is guilty of revoking the offer, as it cannot be done after the requirement has been met by the offeree. The other point is for both Mickey and the Brett, who should be given the award as they deserve the car. And this is the second case, and Manisha will continue from here, and which is yeah.
Hi, I'm Manisha. I'm going to talk about corporations law. The issue here where the duty, care and due diligence is like every director of a company, he has the main duties to take care what has to be done, what not has to be done with the proper due diligence. In this, we talk about right of shareholders and directors of a company. As per the section 249A of Corporations Act 2001, directors have all the right to call up a meeting whenever it is necessary to talk about, to disclose, to discuss about the things. And as per the section 250E of Corporations Act 2001, every shareholder has a right to vote. Individually, each shareholder's one vote counts to one, not multiple votes. Shareholders cannot make multiple votes. And the rules regarding the duty of care and due diligence. Section 181 of Corporations Act 2001, this act talks about the performance of duty with care and diligence towards the company. And section 180 subclass 2 of Corporations Act 2001, the director makes a business judgment. Every judgment made by a director should be done within the favor of the company. It shouldn't be made for a personal advantage which can favor any of his favorite person in the company, nor for any personal benefit of himself. Rules regarding the insolvent trading by the corporation. This section 588G of Corporations Act 2001, it is the duty of the director to prevent any insolvency, upcoming insolvency cases regarding the trading. As like a director, it is his duty so that the company should not go insolvent. He has to make necessary arrangements regarding this. Now my friend Vinod will continue after this. Thank you.
Hello, my name is Vinod. My student ID is APS3592. I will continue from the case of Mercedes. There is a breach of the Mercedes duty of care and diligence as a director of the company. Felix ensured the new place for the company is better for the corporation and the best of its interest. Therefore, Mercedes decision and agreement to the Felix decision was protected by the section 182. And there is a case of Greg, the breach of Greg's duty of care and diligence as a director of the company, and because the Felix concealed as the detail under section 588A, he is responsible to prevent the company from the upcoming insolvent. And in the last, Innovest Demolition Private Limited, the versus Silk 2018, and the section 136 588 insolvent trading proceedings. Innovest alleges that on August 30, 2013, the plaintiff and the bureau entered into the agreement. The plaintiff alleged that when the debits under the agreement were incurred by one billed or not, and that would become insolvent by the incurring each debit under the agreement. A conclusion is that the breach of Greg and Mercedes duty of care and diligence as a director, and Felix did not provide them that adequate detail and did not allow them to explain the options. Thanks. That's it.